Greetings, my fellow freedom lovers and solving thinkers. This is LL3's newest podcast. My name is Craig. I've been having some technical difficulties, so bear with me on this. And today is March 17th, 2014, and hopefully everyone had a great St. Patrick's Day and pay homage to St. Patrick instead of posing like you're a wannabe Irishman and Irish girl want to get drunk. Because as far as I'm concerned, that's nothing but pure blasphemy. Well, today I want to be reading a few articles, and this one here is very good, I would say. All of them are arguably good. First one is going to be from Suzanne Pazel from OccupyCorporatism.com and the USIndependent.com. And it's considered to be an exclusive. It's entitled The Secret Theft Mechanism of an American Foreclosure. And I'm going to read it right now. One foreclosure case in Washington State that is still ongoing has raised the not-so-obvious question of whether or not banks are essentially writing blank checks to take homes from their owners. Revelations from evidence in the case Kench versus the Fidelity National Title Insurance have shed light on one interesting way banks have begun the process of theft before the foreclosure is first enacted. Scott Staffney, attorney for Kench and partner with the Staffney Trumbull law firm, filed a declaration with the U.S. District Court for the Western District of Washington at Seattle, and Judge Richard A. Jones explained to one ingenious scheme the banks use to take homes from their homeowners based on a general principle of ignorance that is well-known industry standard. In his declaration, Staffney exhibited for the court the document used in take Kench's home and initiate the foreclosure process. This document appears to be official, yet is all that is needed from the bank to begin the process of foreclosure. Exhibit 1 of Staffney's declaration reads, the undersigned beneficiary or authorized agent for the beneficiary hereby represents and declares under the penalty of perjury that the beneficiary is the owner of the promissory note or other obligation secured by the deed of trust. This document is signed by Kathy Smith, signature of mortgagee, beneficiary of authorized agent. Staffney showed that Smith cannot be the beneficiary as described in Washington State RCW 61.24.030, which defines the beneficiary as the holder of the instrument or document evidencing the obligation secured by the deed of trust, excluding persons holding the same as security for a different obligation, because she is a robo-signer for hire. Smith was hired by Countrywide Bank in 2010 to robo-signing a foreclosure according to documents provided from another foreclosure. In that same year, Smith was employed by American Brokers Conduit for more robo-signing to steal homes from owners. Yet again, Smith robo-signed another foreclosure into existence as an employee of Lender Processing Services, and this time she should also claim to be Assistant Secretary MRES or MERS as nominee for American Home Mortgage after a change to the original document was made by the bank to cover Smith's tracks. Shockingly, in a disposition with Staffney regarding the Kench foreclosure, Tamara Yellen, staff attorney for Default Resolution Network for Fidelity National Title Insurance, explained how her organization did not have 100% proof that they had real possession of title before initiating the foreclosure process. Yellen explained to Staffney that she is not certain of the exact corporate structure of the corporation she works for. However, they operate as FNTI in the state of Washington. We are all division of FNTI as an overall parent company. We are all divisions of the Fidelity National Financial, FNF. Yellen told Staffney not all states even require a declaration under penalty of perjury that you are the owner of the note. because there are hundreds, if not thousands, of securitized trusts out there, and we were to review every securitized trust agreement, we wouldn't be able to do business. Staggeringly, toward the end of the deposition, Yellen revealed that FNTI had commenced a substantial amount greater than 1,000 non-judicial foreclosures in 3 or 4 days prior to the deposition in Washington State alone. According to Washington State RCW 61.24.30 to be exact, subsection 7A, a declaration by a beneficiary made under the penalty of perjury stating that the beneficiary is the actual holder of the promissory note for other obligation secured by the deed of trust shall be sufficient proof as required under this subsection. Yet Yellen, working for FNTI, who have initiated foreclosure against Kent, admitted that they do not know who actual holder of the mortgage note is. Smith, a hired robo-signer, declared that she is the holder of the actual mortgage document. However, she has made that declaration before countless other employers. The punchline of Staffney's declaration is found in Exhibit 2, where Deutsche Bank National Trust Company sent the homeowner another robo-sign foreclosure initiation document dated 2 months into the future. And the document was right there, and the borrower's name is John D. Kinch. And the date is 5/14/2014, or other words, May 14th, 2014. And the signature of the mortgagee, beneficiary of authorized agent, may be rubber stamped Daniel Statton, who's the vice president. The thieves play on, I call it. It's so funny because there's a big thing really happened with the whole foreclosure scandals and shams, etc. I do recall one time with Bank of America was trying to get foreclose a home in Collier County, Florida area, over around Naples, and the person had proof that it was all paid in cash. Sued him, won. He was awarded a good amount of money. Bank of America wouldn't reply nor appealed, so he went further, took it to the courts, and they told him pay him. Then one day, the judge signed a court order to seize all assets pertaining to Bank of America in that branch in Naples, Florida. Plus, he ordered 2 deputies to escort the person to take all the goods away. Doesn't matter, computers, money, anything that pertains to that particular bank. The branch manager almost took a soil in his pants, had to call his boss, and they finally paid the man. As far as I'm concerned, with all these foreclosure schemes, they should just file charges against these people under the RICO law, which is under Black's Law's Dictionary. You can look at, I will put that link on there, it's thelawdictionary.org. And it says here about RICO, an act that was passed by Congress in 1970. It was established in order to increase the penalties that were imposed for acts of crimes committed by organized crime, such as the mafia. Hell, you should put the big tyrannical corporate banks and government as well. Its establishment has allowed the better prosecution of organized criminal acts. Yeah, so the plot thickens, and a lot of the banks and these financial companies that are involved in foreclosures are getting their hands caught in a cookie jar, and the mousetrap gotten a lot bigger. As far as I'm concerned, they should file RICO charges, and in addition, and anyone who gets screwed by these bastards I recommend you file Title 42 U.S. Code Section 1983 to get compensation by violating your constitutional or natural-born rights. It's that simple. All right, well, we're going to hit the next one here, next article, which was from the Liberty Crier, and it was actually released on the 16th, but how to address this. It was about the Ars Armor. I know they're being harassed by the city for their sign, and now the ATF raided their place. It's called ATF Raids Ares Armor and accuses them of illegal gun sales. There's a video on that as well. According to Jerry Tuma, the chief operating officer of Ars Armor, that the ATF raided their store on Saturday at about 12:50 p.m. The ATF executed search warrants at all Ares Armor locations. For those not familiar with the case, Ares Armor was attacked by the local government over the display of the sign. The company was then asked for a list of their customers by the ATF. Ares then filed for and was granted a temporary restraining order, TRO, against the ATF. District Judge Janice L. Sammartino of the United States District Court, Southern District of California, issued an order Friday to prevent Oceanside gun parts suppliers Ares Armor on divesting itself of inventory and records subject to a temporary restraining order the court issued Tuesday. Also included in the order was notice that the TRO did not restrain lawful criminal proceedings, as well as a modification of the briefing schedule ordering the parties to fully address all the facts and circumstances as alleged by one another. The raid on Ares Armor was connected to another ATF raid which occurred in Bakersfield, California on Friday afternoon. The facility for EP Armory, along with owner Chris Cook's home, were searched. ATF agents indicated that they were looking for illegal guns. EP Armory is known mostly for its innovative 80% complete AR-15 receivers made of strong Kevlar reinforced polymer. By using different color polymers for the portion that are to be milled away, a drill and a Dremel can be all that is needed. Ars Armor sells these EP Armory products. When the ATF raided Ars Armor, they demanded that they hand over all of EP's Armory's 80% lowers and a list of customers who purchased these products. On Saturday, the CEO of Ars Armor, Demetrios Karas, issued the following statement on their Facebook page. The ATF did execute a search warrant against all of our buildings today. None of our employees have been detained or arrested. We will open for business tomorrow. We will be back up and shipping out orders on Monday. We wholeheartedly believe they are wrong in their actions, and we will be relentlessly pursuing remedy through the courts. Quote from the ATF agent during the raid: searching is fun, paperwork sucks. Maybe the ATF thinks the Constitution is part of that paperwork that sucks. Despicable behavior on their part. It is just the beginning. Thank you all for the support. Ars Armor has posted a timeline on the entire dispute here. It's a very good link. Just has all the videos and a good interview that was done by the folks representing Nothing Fancy via YouTube. It's all on there, and they give you all the details of what happened. You can find additional information by following Dave Workman, David Cordia, and Kirk Hoffman. In the meantime, you can help out Ars Armor by purchasing their products. In a statement, the CEO said, "We cannot accept donations. However, a significant portion of all purchases will be going directly to our legal fees. If you live in California, you're also urged to contact your local representatives and respectfully ask them to leave Ars Armor alone." I do agree completely, because I have addressed this incident a couple of weeks ago with the National City Council, or harassing them over the sign. And I know for sure the National City Council had knowledge of the ATF, and they let them do it. So far as I'm concerned, they're nothing more than a bunch of treasonous bastards. In addition, where was Sheriff William Gore, who is who represents that county? Where was he? Did he let the ATF raid their store too? Because in good faith, he has a 10th Amendment obligation to tell them to get out of his county or get arrested. If he believes the feds should just go in there anytime, he needs to get thrown out for breaching his oath of office. All right, and if he had knowledge and supported the cause, You should get him out too for RICO.